All right, I think we're ready to begin. Our next panel is called Civilian Perspectives on Victim Participation in Judicial Proceedings, and it's a perfect segue to the panel that we had earlier. So let's get started. We've delayed everybody. I apologize. And we'll start. Is that Mr. Malios?
Yes. Thank you. Good afternoon, and thank you for inviting me to speak. I am an attorney advisor at Equitas, which is a resource center based in Washington, D.C., funded by the Department of Justice. And our mission is to improve the quality of justice in sexual assault, dating, and domestic violence cases, as well as stalking, elder abuse, and human trafficking. We have 6 former prosecutors. I am a former prosecutor, and I travel around the country providing training and technical assistance to prosecutors, police, advocates, medical professionals in the response to violence against women. I have also trained hundreds of military prosecutors through contracts that Equitas has had with the different branches of the armed services. And I've been to a faculty member at the Navy's Institute on the Prosecution of Alcohol-Facilitated Sexual Assault. And I'd like to speak a little bit about some of my observations, what we found successful in my practice in Philadelphia at the District Attorney's Office there, what some of the best practices are around the country, and also some of the comparisons that I've seen between the civilian justice system and the military justice system regarding the rights of victims. Starting with investigations, it seems to me that there are some differences in the way the military conducts its investigations, especially with respect to these collateral crimes, or what I like to call petty crimes. Most civilian prosecutors are very eager to make it clear that victims will not get in trouble for admitting to things like underage drinking or smoking marijuana when they are victims of serious crimes such as rape or sexual assault. And it's so important for a victim to be able to make a truthful disclosure the first time they meet with a law enforcement officer without worrying about those charges being filed against them. And I've heard again and again that that is a recurring problem in the military justice system. And it also discourages people from reporting or disclosing. It's a very similar problem to what we see on college campuses, where violations may constitute petty crimes as well as violations of university policy. And universities also are very fast to offer some sort of amnesty to victims who come forward to make sure that they will not get in trouble and that they don't have to worry about getting in trouble. And when there's a coordinated response in a jurisdiction, when the advocates know, when the people answering the telephones at the Rape Crisis Center, the medical professionals, when they all know that this is the policy, then they can all explain that to victims in a way that does encourage reporting and it encourages truthful, honest disclosures. I also worked in a large office in Philadelphia with 300 prosecutors. We had 20 prosecutors in my unit. I was the chief of the Family Violence and Sexual Assault Unit. And specialized prosecutors are by far one of the best ways to protect the rights of victims and ensure a higher level of offender accountability. In order to get into my unit, someone had to really excel in working their way up through the district attorney's office, 2 or 3 years of trying misdemeanor cases, a large volume of misdemeanor cases, before they could apply to come to my office, to my unit, and have an interview with me and other supervisors to make sure not only that they had the legal skills that we were looking for, but also the type of sensitivity that told us that they were willing to learn about the dynamics of sexual violence and that they were willing to modify their approach to cases to work with victims of sexual trauma in a way that ensured that the criminal justice process, as much as we could, did not victimize them any further. There were lots of excellent prosecutors in our office, in the homicide unit and the major trials unit, that I would never have let try one of my cases in the family violence and sexual assault unit. And I can't help thinking, I like to think of the district attorney's office as a law firm, and I think that maybe the JAG Corps of the armed services are law firms. And if there were some way to carve out some specialized prosecutors who are attending national trainings and local and regional trainings, who are collaborating closely with medical professionals, mental health professionals, and victim advocates, that's such a powerful way to improve the justice response for victims and make the system work better. Another significant difference between the civilian justice system and the military justice system, as I understand it, are these Article 32 hearings. Most jurisdictions do either grand jury indictments or preliminary hearings. And for strategic reasons, a prosecutor at a preliminary hearing wants to keep that testimony as short as possible. We want to establish a prima facie case, get the case held over for court. Victim credibility generally is not an issue at a preliminary hearing. The prosecution is entitled to that presumption that the victim is credible. There would be absolutely no reason for rape shield questions to be asked or any attempt to pierce a rape shield at a preliminary hearing. Any embarrassing or private information in the victim's past would just simply be irrelevant. And as I understand it, the Article 32 hearing is both a test of the evidence for a prima facie case and also a sort of discovery deposition for the defense. And I just can't imagine putting a victim through that type of adversarial, extensive cross-examination at such an early stage in the proceedings, and then with the understanding that they're going to have to go through even more of that at a later date. And I'm not advocating that there be a different system just for sexual assault cases. I would suggest humbly that perhaps this is an area where the military justice system needs to look at the way the civilian system does it and keep the hearings, the test for a prima facie case short, and then have some later proceedings for dealing with discovery the way the civilian justice system does. In sexual assault cases, I think it would be especially important because victims do need those protections, and these cases are so adversarial, and victim credibility is such an issue. When you're dealing with non-stranger cases where the victim and perpetrator know each other, the issue is always going to be the credibility of the victim. And when there's a blistering attack on the victim's credibility at such an early stage in the proceedings, that really can have a chilling effect, and it's something that perhaps could be avoided if the system mirrored the civilian justice system a little bit more than it does now. With respect to victim rights attorneys, one of the questions that was presented to us as panel members is what is our experience in the civilian world with victims' rights attorneys? And I have to say that my unit prosecuted rape, child abuse, and domestic violence. And in the area of child victims, we had a lot of victim rights attorneys because there were frequently parallel proceedings in dependency court when children were victims of sexual assault or physical abuse. There were family court proceedings as well as criminal justice proceedings. But in the area of adult sexual assault victims, it was fairly rare in my experience to have victims' rights attorneys or victim attorneys in our cases. If there was a civil case, if the victim was seeking damages from someone, an employer, from the perpetrator, from a landlord, from a university, we might have a civil attorney in those cases. But their role really was to advise the victim on the civil consequences, on all aspects of civil litigation, as well as to act as a liaison to the prosecutor on the consequences of the prosecutorial decisions on civil cases. Sometimes we would have victims who are reluctant, and it's not uncommon for a sexual assault victim not only to not want to report, but to at some point become uncooperative in an investigation or a prosecution because they realize that private, personal, embarrassing information may be revealed, and frequently that victims want to just stop the process. They don't want to go forward. And we would always do our best to try and encourage victims to go forward. Sometimes their desire not to go forward would take the form of a recantation. And in those cases, sometimes a judge would appoint an attorney if a victim was recanting because there are then Fifth Amendment issues. It was our practice in Philadelphia not to force victims of sexual violence to testify if they didn't want to. But we would try to persuade them to change their mind and persuade them to recant sometimes their recantations. And we would work closely with civil attorneys actually criminal attorneys appointed for victims in those cases. Another area where we saw victims' rights attorneys would be in situations where victims' personal private information was being subpoenaed, usually by the defense, almost always by the defense, but a couple times prosecutors sought information that victims' attorneys stepped in to help with. There were lots of times when the prosecutors, as prosecutors, we would ask that subpoenas be quashed, and we would try and protect victims' privacy in those ways. But when a victim has an attorney, either appointed or hired, or more often than not a pro bono attorney from one of the anti-violence against women agencies in our city, they have confidentiality with that person, and they could talk very frankly with their attorney about what information was in those records, whether they were mental health records, medical records, sometimes school records. They could talk their attorney with the protection of attorney-client privilege about what information they did not want to be released. And I think that that's appropriate. I think that they need that level of confidentiality because there are some things that they may not want the prosecutor, and frankly, that I don't want to know. I do not represent the victim. I represent the state, the government, in my case, the Commonwealth of Pennsylvania, and there would sometimes be personal private information that would be better protected by someone who had that confidentiality with the victim that I could not offer them. And that was fairly common. That was probably the most common reason that we would come into contact with a civil attorney or a victim's attorney, was when there was a subpoena for personal private information. Sometimes in an attempt to discredit a victim, the strategy will sort of shift into trying to make the victim appear unlikable and bringing out things in the victim's past like prior drug abuse or bad mothering. Maybe there had been family court involvement, any type of neglect. Really, these issues have nothing to do with the crime that the perpetrator committed against the victim. But if an attorney can make these proceedings so unpleasant and so embarrassing for the victim that they, in balance, decide they don't want to go forward, then that's a way to further the rights of the accused. And it's not uncommon, in my experience, to see that happening. With respect to post-trial review, I'm astounded by the fact that military appellate courts are able to reweigh credibility in the post-trial phase based on a cold record. I did 2 appellate clerkships myself, and you just can't make those types of credibility determinations. If a panel has looked someone in the eye after they have been subjected to adversarial cross-examination, and that panel has found proof beyond a reasonable doubt that they're credible and that the elements of the crime are met, that type of review and that type of reassessment of credibility, it's just so counterintuitive to everything I learned in law school and everything I've ever seen in the practice of law, especially in the case of sexual assault cases. Sometimes the facts of these cases are frankly very unusual. They may seem implausible. Sex offenders, especially repeated sex offenders, whether they've been caught before or not, become very crafty in how to create situations that seem implausible. They pick victims who they think perhaps are not likely to report. They pick victims who perhaps are not likely to be believed if they do report. And they sometimes say things and do things where they are essentially playing to the audience. And they create situations where when you look at a police report or an investigative report, you just think, wow, this doesn't make sense. No one would do this, or why would someone do this? And then you sit down and you meet the victim, and you look the victim in the eye, and that cold report is just changed, and it becomes real when you're able to hear it from the victim, when you're able to ask questions. So the thought of either an appellate court reweighing and reviewing evidence, or even a commander making an just word in favor of the accused after the trial. These are things that would not happen in the civilian world. And both aspects, the appellate review and the commander's power to adjust cases in favor of the accused, they only provide additional obstacles for victims to obtain justice, and there are additional obstacles for offender accountability that do not exist in the civilian justice system. So I don't know what the powers of this panel are to change those types of things, but having personally tried hundreds of rape cases and having supervised the prosecution of thousands of rape cases, I can say these are difficult cases, but they are cases where with the right approach, with the right staffing, and with the right training, and also a high level of experience, we can obtain justice for victims in an adversarial criminal proceeding with the high burden of proof beyond a reasonable doubt. My understanding is that frequently the prosecutors that I train, the military prosecutors that I train, are only there for a 3-year assignment. And in my office, at 3 years, they're just learning how to try cases. I worked in an office with career prosecutors. I was a prosecutor for 16 years, but we had 20, 25, and 30-year prosecutors. And of the 20 prosecutors in my unit, I had about 4 or 5 go-to people in my bullpen that I could, when I assessed a case and I determined that I needed one of my heavy hitters, I had those people to go to. And I think that all branches of the military need that level of experience for the most serious cases, and I think that these types of cases should be within the group of the most serious cases that are going to the most experienced prosecutors. That's my testimony. I'd be happy to answer any questions you have.
Thank you very much.
You're welcome.
Next, we'll hear from Ms. Theo Stamos, who's the Commonwealth Attorney for Arlington, Virginia. Ms.
Thank you.
Stamos?
Good afternoon, and thank you for the invitation to appear today before this important panel. My name is Theo Stamos. I'm the Commonwealth's Attorney for Arlington County and the City of Falls Church, just about a 10-minute drive across the Potomac from here. This afternoon, I thought I would take a few moments to talk about my experience as a sex crimes prosecutor, discuss some of the issues that I believe are of interest to this panel, and then answer any questions that you might have. I've been a prosecutor for almost 27 years, and for a good portion of my career, I was the lead sex crimes attorney in my office. The most significant development in the prosecution of sex crimes during my tenure has, of course, been the introduction of DNA evidence. Arlington County was among the first jurisdictions in the nation to successfully use DNA evidence against a serial rapist named Timothy Spencer, who was convicted of rape and capital murder in the late 1980s. The second most significant development, in my view, has been the creation of victim witness programs, which have grown up alongside the victims' rights movement. My office has a staff of 7 victim witness specialists who work alongside our prosecution staff in preparing sexual assault victims for the rigors of a criminal trial. My director, Autumn Jones, addressed this panel yesterday on the work of her unit. I can tell you from a prosecutor's perspective that the victim specialist is an invaluable ally. They routinely introduce our victim to the criminal justice system. They explain to our victims what their rights are, and they provide the guidance on the often complicated court process that they are about to embark upon. And they create a critical bond between the prosecution team and the victim. In short, they allow us, the prosecutors, to focus our energy on trial preparation and strategy, while at the same time allowing prosecutors to know that our victims are well cared for. I understand that there is much discussion about victim attorneys as perhaps the next step in the victim rights movement. I have to say quite bluntly that this strikes me as a bad idea. The first concern is a very practical one. In Virginia, as elsewhere, the Code of Professional Conduct prohibits a lawyer from communicating with an individual about the subject matter of the representation if that individual is represented by counsel. In order for me to meet with, interview, and prepare a rape victim for trial, I would first have to get the consent of the victim's lawyer. And while that might sound simple enough, in my view, it injects an unnecessary wedge between my victim and me. I understand that the military setting is in many ways different than the civilian setting when it comes to the prosecution of sexual assault cases, and additional considerations might exist for sexual assault victims for a sexual assault victim who is a member of the military that don't exist in the civilian setting. However, I firmly believe that if we are doing our jobs correctly, with the dedication, professionalism, and sensitivity that these types of cases demand, victim attorneys would really be a redundancy. Thank you, and I'd be happy to answer any questions you might have.
Thank you, Ms. Stamos. Ms. Marjorie Fisher is next. She's chief of the Special Victims Bureau in Queens, New York. And Congresswoman Holtzman says hello. I think she said hello earlier as well.
Okay, thank you. Can you hear me?
I can.
Okay. Your Honor, Madam Chairperson and panel members, thank you for having me.
Now I can't hear you.
Oh.
So, if you could just...
Here, you know what? I'll move.
No, I think that one works. It's just, you need to be a little closer. Thank you.
Thank you for having me. As a sex crimes prosecutor for over 30 years and the bureau chief of a major metropolitan sex crimes bureau for over 23 years, I have thought a great deal about what prosecutors can do best to serve victims of sexual assaults. So you know where I came from and where I work. Queens has been the most ethnically diverse county in our nation, with 2.2 million residents speaking over 140 languages. We have many challenges, and I would like to share a few investigative tools that we've been using that have really allowed us to be very successful in this field. I was asked to come and speak to you to answer the question, what works best to achieve justice and optimum victim satisfaction and victims' rights protection in the civilian world of sexual assault prosecutions. Thank you for the opportunity to share my insights. My experience is that what serves all of our victims most and ultimately protects their rights is an effective and successful prosecution by well-trained and experienced ADAs. My bureau has 14 ADAs. As I said, I have 30 years of experience and I try cases pretty regularly. My bureau consists of people with 15 years, 18 years, 19 years of experience. And that is a critical contributor to a 95% conviction rate after pleas and trials. The components, I believe, of our program, along with extremely experienced and well-trained ADAs, are many, but if I could mention 4 of them that occur in the investigative stage, they would be our early case enhancement program, vertical prosecution, pre-arrest interviews of victims in difficult cases, and an effective team approach with our sexual assault forensic examiner program that is also linked to a 24-hour volunteer advocate program in our hospitals. For each of these components, the critical word is early. The primary determinant of the ultimate success of our prosecution is what happens before the handcuffs are placed on the wrists of the perpetrator. The determinations and the enhancements made to the case in the very, very first hours after the crime occurs or after the outcry is made account for our successes and ultimately, I believe, for optimum victim satisfaction. Let me first talk to you about our early case enhancement program. February 14th, 1992, that's over 20 years ago, the Special Victims Bureau in Queens, under newly elected District Attorney Richard Brown, instituted an early case enhancement program in special victims known as the Riding Program. And this program was devised to address problems unique to the prosecution of sex crimes cases by having an assistant DA meet with the victim at the earliest stage of the case to make the victim feel involved in the investigation, to lessen his or her trauma, and to work together to figure out where the evidence is. To staff this program, I have an ADA on call 24/7 every day of the year. And they work probably once every 2 weeks on call. And sometimes they get many calls, and sometimes for a month they get no calls. But every time there's an arrest for a first-degree sex crimes in Queens County, a sex crimes prosecutor goes to the precinct or the hospital to enhance the case. Why do we do this? We're seeking to establish a rapport with the victim, to explain to the victim what's going to happen next. And then, only after that, when she or he feels safe, will the ADA proceed to interview the victim about what happened, and then they will supply immediate counseling referrals. In most cases, we have vertical prosecution. What is this? The same ADA who meets the victim in the precinct, the hospital, the street, will be responsible for handling that case through disposition, if it's a negotiated plea or a trial. They work with the police to secure evidence, and one of their key goals is to take a videotape statement from the defendant. And we feel that by sending an experienced sex crimes prosecutor to the precinct immediately after the defendant's arrest, these goals can be achieved, and in doing so, we turn marginal cases into strong ones. I also feel, having gone out many nights myself, that there is a real benefit when the ADA meets the victim, could be in the middle of the night, and he or she sees that this is the person who's going to handle the prosecution. And they don't have to repeat the story over and over again to countless people over the course of months while the case gets transferred from one lawyer to another. This is an ADA who is experienced in sex crimes prosecution, sex and sensitivity to these victims. Over the past 20 years, we have written hundreds of cases at all hours of the day or night. In each of these cases, a special victims ADA will go out to the precinct, they'll interview the complainant, and they enhance the case with some combination of identifying additional witnesses, whether it be for the people or the defense, taking a statement, as I said, drafting a search warrant based upon what the complainant says and going right to court and getting it signed, and providing counseling referrals. And what I will tell you is that the victim comes away feeling like my case is being handled by a professional, a legal mind at the scene who cares about my well-being and who will remain my primary point of contact as the case proceeds. And this has a tremendous effect of reducing anxiety. In about 25% of the cases, the ADA who tries the case takes a videotape statement from the defendant, and they range from denials to alibis to confessions. I will tell you that this initial encounter really improves our chances of getting the victim to come forward at the grand jury and finally a trial. It helps eliminate the psychological limbo that may happen between the hospital and when they ultimately come to court. And I can't tell you how many times that our victims have said to their ADAs at trial, a year or two later, the only reason I'm here to testify is because you were there for me in the middle of the night, during the worst hours of my life. I will tell you that that bond builds trust, and it leads to greater openness on the part of the victim in terms of her willingness to completely and accurately and truthfully relate all the information to the prosecutor without fear of judgment. And of course, this ends up certainly combining to achieve success at trial. Also, the fact that we have vertical prosecution and the person who is on the street or in the precinct who's going to try that case turns out to give tremendous incentive to enhance the case as well as you possibly can. And as I said, in approximately 95% of the cases that were enhanced at the beginning and indicted, convictions resulted. And in close to 25 cases, defendants made statements to their the ADAs. And just as important as to of those cases that added to the success in getting a conviction are those cases where the ADAs have released defendants where there was insufficient evidence to support an arrest. In approximately 10% of the rides done over the last 20 years, our assistant DAs have exonerated suspects and released them, or at the very least deferred the prosecution until additional evidence could be obtained. Another component of our successful prosecutions and ensuring victims are satisfied is that we have a great relationship with our SANE, SAFE, SART program on the hospitals. Now, in Queens and across the city of New York, when a rape victim gets into an ambulance, the ambulance will ask them, do you want to go to a center of excellence for sexual assault? They give them the option of going outside of the catchment area and going to these wonderful hospitals where they are seen within 1 hour by a sexual assault examiner on call. This examiner is a person who has been trained extensively, not only by doctors, but also by prosecutors on what to expect in court when they come in and testify, and it's wonderful. They are also extremely successful and much more successful at at finding DNA evidence than the non-SART programs, and we have evidence to prove that. I will tell you, in our county, they've done over 1,000 exams. We can reach them in the middle of the night to get results of exams. We work with them constantly to work on systemic problems in the hospital. And gone are the days when victims of sexual assault are examined by a radiology resident who has no idea what these exams entail and hasn't ever conducted such an exam, and who are uncomfortable performing a sex assault exam, and who have no particular interest or concern for the patient. So that's a wonderful team effort that we have been involved in. One other thing that I'd like to mention is that we have another team effort with our detectives, and in about 25% of our cases, our detectives call us and bring in victims in cases where there has been intoxication, where they know each other very well, where there's some kind of complicating issue, and these are many of our cases. And this is our pre-arrest interview program, and what we do is it could be weeks before an arrest is made, we will do that interview with the detectives, and we'll determine whether there's any more evidence that can be gathered before an arrest is made, or whether there should never be an arrest made. And that's a wonderful program. The most frequent thing that we do with our victims in this program is that if the perpetrator is not aware of the allegations, the detective and the ADA will work together with the victim to do a phone call, which is being recorded. And the ADA is integral to the production of this because they know what will work at trial. And it shifts if we do get a statement, which in an amazing number of those cases, we get a recorded phone call that works in court, it shifts the burden of proceeding from the victim to the victim and a confession on this phone call. And it empowers the victims and it makes them feel more involved. Finally, one of the most important ingredients for a successful investigation of these cases is that you have a victim who's strong enough to go forward. And we have a volunteer effort with a major hospital in New York, Mount Sinai, where they have hundreds of volunteer advocates that are trained by prosecutors, police, and doctors about how to respond to a rape victim. And they will come out, they're on call maybe once a month or so, and they'll come out and sit with the victim in the hospital overnight. They can even go to the precinct with them, and they will be there for them to help them and to bridge the gap between when they leave the hospital and when they go to the precinct, and it's a wonderful program. In addition, I would tell you that the value of having a non-party, non-lawyer advocate to offer a victim emotional support at that stage is enormous. The ER advocates are trained and wonderful, and they hand off the case to a specially trained social worker once they get to the DA's office. And that combination of help helps victims and guides them through what, as you can imagine, is a very confusing and intimidating process. At the same time, the prosecutor, with that backup, can focus on the legal aspects of the criminal case, knowing that the victim's emotional needs are being taken care of. And the prosecution is strengthened by having a single attorney build a relationship with the victim. The advantage of this approach is clear. When it comes time for the victim to provide testimony, she's received emotional and psychological support in the aftermath of her attack, and she has a solid connection to the DA who's been with her throughout the process. In New York City, the instances of victims retaining counsel is rare. It happens maybe twice a year in a very busy county in which I work. My view, and that of many of the ADAs that I work with, is different from many who've spoken today who have served as victims' counsel, excuse me, or have seen them in their courtrooms. Some of the things that they offer are amazing and wonderful and seem to really feel a need. But my concern with retained or victims' counsel is that just because we represent the people or the government in our cases, it doesn't mean that our work somehow ignores or neglects the rights of the victim. She or he is our paramount concern, from the pretrial rape shield motions to ensuring her right to speak at sentencing. Our victims know this. And after 30 years, I believe that the victims are comfortable with the combination of prosecutor and advocate that I have described. I worry that if the victim had their own lawyer in every single case, that the relationship that I think is sacrosanct in our office that exists between the victim and her counsel could circumvent or diminish the critical relationship that my ADAs have with their victim. And that is a victim that fosters trust and full disclosure. I'm also concerned that were the victim to have an attorney apart from the prosecutor, the victim could disclose facts to her counsel that were not disclosed to the ADA. And the counsel has a complete privilege with the victim, and they might not be able to share those facts with the prosecutor due to the limitations of the attorney-client privilege. What then happens if the victim's counsel receives information that could be exculpatory, that is Brady material, which must be disclosed to the defense in a criminal prosecution by the DA? What happens if the victim's rights attorney takes a position contrary to the prosecutor? These are my concerns, and I would recommend a commitment to specialized training for sex assault prosecutors in the military who stay with that job on how to build an open, candid, and supportive relationship with victims, rather than wholeheartedly supporting a system that introduces another attorney into a delicate, sensitive, and difficult case. I would close by saying to you that although my responsibility as a DA is to seek justice, and I represent the government, the relationship that I and my DAs have with their victims is extraordinary. It is not unusual for our victims to come back year after year and see us, regardless of the result. Recently, one of my ADA's victims named their baby after our ADA. They sent holiday cards, they send wedding and birth announcements to their prosecutors. This bond that's created through the early case enhancement and prosecutors' dedication to the victim, from the hospital to the precinct, through the trial to the sentence, is a worthy goal that leads to not only just outcome, but it also leads to victims and healing. And I just want to finish by reading you a letter that one of my ADAs got from a sex abuse case that was tried 2 years ago. A woman and her sisters who were all raped by their father over and over again. She writes, "I plan on going on to establish a foundation to help others in situations like mine who are just in need. In a situation like this, the typical thing is to be battered, sad, scared, and defined by my past. But that is not me. I am an overcomer who has been blessed to have God put such amazing people in our lives to support and defend us. You have done everything you could. I know without a doubt if we had to go to court 6 times, you would stand by us. You are an amazing person. I admire what you do. You know what? In this process, I have walked away knowing amazing people like yourself that I will always hold very close to my heart. Thank you for your help and support, and may God bless you and your family beyond measure. Remember, this is the beginning of a beautiful story." My conclusion is the components of a successful sexual assault prosecution that I have outlined here have produced just results in the courtroom, while at the same time making it a priority to minimize further trauma to the victim. I believe that some of these tools might be able to be used in the military sexual assault arena without compromising in the slightest the traditional relationship between the prosecutor and the victim. Thank you so much for allowing me to share these thoughts.
Thank you, Ms. Fisher. We'll now hear from Ms. Kelly Luther, who's the Deputy County Attorney, Maricopa County, Arizona. Ms. Luther?
Thank you. Your Honor, members of the committee, it is truly an honor to appear before you today and share with you my professional experience as a former victims attorney, representing not only adult and child victims of sex crimes at the state and federal level, but also victims of homicide, aggravated assault, and even financial crimes, as well as currently a prosecutor in a jurisdiction that victims' rights have been embedded in our Constitution for over 20 years. I'm currently a Maricopa County Deputy Attorney. I focus on victims' rights issues at trial and appellate level for my office. The Maricopa County Attorney's Office serves metropolitan Phoenix and the surrounding areas. We're the fourth largest county in the United States with over 4 million residents. The Maricopa County Attorney's Office prosecuted over 314 sexual assaults and sexual abuse cases in 2012, and thus far in 2013, we have 220 filings. Back in early 2002, constitutional protections for crime victims had been on the books for over 10 years. These constitutional protections even included an expedited appellate remedy for violations. Still, far too often, victims' rights violations were far too frequent. My mentor and former Arizona Assistant Attorney General Steve Twist, who is a career prosecutor, dared to wonder out loud if the rights of crime victims might be better protected through the retention of specially trained counsel to assert the rights of victims throughout the criminal justice process. Again, this is 2002. What if a crime victim retained an attorney for the sole purpose of effectuating her rights within the criminal justice process? Such representation would include educating the victim on the criminal justice process, meeting with the prosecutor, appearing on behalf of the victim in court, filing appropriate motions, and preparing the victim for trial and sentencing. The grand constitutional experiment began. Most importantly, we posited the question as to whether it was truly possible to protect the constitutional rights of both the accused and the victim. Well, in Arizona, after representing crime victims in felony cases for over a decade, the resounding answer is yes. This is not a zero-sum game. The rights of the defendant are not diminished by enforcing the rights of crime victims, including their right to counsel. In fact, it's our belief that representation may indeed increase the odds that the rights of the accused are protected. While I represented victims, the Victims Legal Assistance Project, as well as the Crime Victim Enforcement Project, one was a federal project and one was a state-based project. We represented over 5,000 victims in both federal and state courts since 2002. And attorneys at the project have logged in more than 5,000 court appearances, including pretrial hearings, trials, and sentencings. Additionally, victims' attorneys have filed numerous appellate briefs litigating various victims' rights violations at the trial court level or supporting trial court rulings upholding victims' rights that are challenged by defendants at the appellate level. Looking back over the last decade, the progress has not been without strife. Our courts are built upon the shoulders of tradition and are resistant to significant change. Understandably, not every judge was a fan. However, the rule of law indeed paves the way. The constitutional calculus guides the judiciary in balancing the rights of all. Upon applying the U.S. Constitution, when the assertion of a crime victim's right infringes on the right of the accused right will indeed trump. However, after litigating hundreds of victims' rights issues, it's been my experience that it's far more often the case that courts are very apt at enforcing the most common rights of the victim, and the enforcement of the right of the victim does not violate the rights of the defendant. Beyond the law, we can't disregard the important emotional support provided by victims' counsel. This should not surprise any lawyer in the room that attorneys are retained to provide guidance and support to their client. With the support and advice of a well-trained victims' rights lawyer, victims can find their voice. I've been told by my clients, most who have never stepped foot in a courtroom, that becoming a victim obviously is incredibly traumatic. We all know that. But then within the fog of trauma, they're tossed into the criminal justice system. It's been explained to me that the experience is akin to landing on the moon or being dropped into enemy territory completely unprepared. This is not Law and Order or CSI. It's a frightening world that victims are ill-equipped to navigate on their own. The language, culture, environment are often untenable. The assistance of a properly trained attorney to translate the culture and provide counsel makes a world of difference. In my experience, I don't think it's realistic for crime victims to expect a great experience within the criminal justice system, whether within the military or in the civilian system, or whether the victim has counsel or not. The most we can do as professionals is to enforce the law at the federal and state level, to try to meet crime victims where they are, attempt to accommodate the victim's needs, and not always expect the victim to conform to our system. Not surprisingly, accommodations can indeed be made for all, defendants, jurors, and victims, that prove the truth-seeking process for all. We can ensure that victims are treated with dignity, respect, as well as fairness, and to be free from intimidation and harassment. An attorney who is well-trained in victims' rights can successfully shepherd crime victims through the gauntlet of our criminal justice system. Additionally, it's important to note that, at least in Arizona, after over 20 years, there are still far too few attorneys representing victims in criminal court. I applaud the innovative SVC programs and the efforts to provide appointed counsel to every victim that desires representation. In Arizona, we're not there yet. Prosecutors recognize that 99% of our victims still will not have counsel, even after 20 years of victims' rights being on the books and enforced. Our Constitution guarantees each of these victims numerous rights. These rights must be protected and enforced. As a prosecutor and a lawyer, it's my sworn duty to enforce the Constitution and laws of Arizona. The Maricopa County Attorney's Office mandates victims' rights training not only for prosecutors, but for every employee. New trial judges in Arizona receive victims' rights training as part of their new judge orientation. Finally, in Arizona, prosecutors have standing to assert any right of the victim. However, prosecutors are not victims' counsel, and attorney-client privilege does not apply. Prosecutors represent the state of Arizona. Prosecutors are bound by the Brady line of cases, necessitating the disclosure of exculpatory information to the defendant. It's essential in our office to ensure justice for all, the victim and the accused. While SVC programs are applauded and welcomed, the entire criminal justice system must make the cultural shift, recognizing that crime victims are not mere pieces of evidence, and victims' rights are indeed civil rights. Victims are participants within the system that have constitutional and statutory rights that shall be enforced. It's a compliance issue in Arizona and at the federal level under the Crime Victims' Rights Act. SVC programs can drive that cultural change one court appearance at a time. However, again, in our experience, most victims will not be represented, at least in the civilian system. Strong laws that prosecutors must enforce and the courts must recognize, I think, is at least part of the solution. I'm happy to answer any questions.
Thank you very much. And now we'll hear from Mike Andrews, Managing Attorney, DC Crimes Victim Resource Center. Thanks.
Thank you, Madam Chairwoman, and the committee for this opportunity to come and speak with you all today. I'm often reminded, having just heard from our distinguished panel, what my father used to say before giving a blessing before we sat down to eat, and his words were, "Make it brief." So with that, I understand that we probably want to get down to brass tacks, so to speak, and have a dialogue with Q&A, and I'll get to that. But just let me briefly just say a couple things. First, again, I'm very appreciative for this opportunity to speak with you. The DC Crime Victims Resource Center is unique because we're the only pro bono legal clinic in the DC metropolitan area that represents crime victims. Years ago, there was several clinics, including ones that Ms. Luther had ran, and with funding restraints, those clinics had kind of went by the wayside. I'm fortunate that DC has been able to maintain our financial stability, but for the most part, our template is with pro bono attorneys, good, hard-working lawyers in the community that are willing to give their valuable time and effort to represent crime victims. And I'm very proud to be one of those individuals. To recommend solutions, I have really one for you all, and that is to adopt the Crime Victims' Rights Act, the CVRA. Real simple. It was passed by bipartisan support, both the House and the Senate. It's been tested. Many of the circuits have come down and on the enforceability. Interesting enough, the head federal prosecutor in the United States, the Attorney General, he has set out guidance that has been straightforward. The CVRA must be applied to all their federal prosecutors. There's no shall, there's no wiggle room. His direction is to the U.S. attorneys, this is the law of the land, and you must comport. And that, as a crime victims' rights attorney, really makes life a lot easier for me because, at least from the prosecutor's perspective, the crime victims attorney is non-threatening. They know what the CVRA is. I will tell you, the majority of my time here in practicing law in D.C. is simply just educating the judiciary and, of course, the defense bar. And it wasn't always easy, I'll be honest with you. There was a lot of, who are you, what are you doing here? And I don't have one with me, but I tell you, I used to have these 3x5 cards of the CVRA. Real simple, non-threatening. How about the first right? The right to be treated with dignity and respect. Really? We have to have a law that says that we have to treat human beings with dignity and respect? And I usually used to tip off with that one. And then we'd go right down the list. But with dialogue and with continuing education, I have to tell you, today I get representations from not only the government, but also from the defense bar. It didn't happen overnight, but it took a lot of work for that. As they see that it's a non-threatening advocacy, especially on certain elements of the CVRA. I will highlight a couple where I think are really relevant for the discussion that I anticipate we're going to have today. The right to be treated with fairness, with respect for the victim's dignity and privacy. This right is essential in preventing unwanted incursions in the victim's background, such as unwanted subpoenas for medical, educational, and unemployment records that are often sought out against the victim of a sexual assault simply for fishing expeditions. And I have litigated this issue on and on again, and I've been successful just for the fact that it's a throw it against the wall subpoena, and there's nothing behind it that would put forth of why there is a need. And I'm often concerned that if that's not litigated, then the privacy right of a victim would then be pierced, simply for the fact that they're a victim of a crime. Had they not been a victim of a crime, they would be having the same protections as everybody else. The second one that I'd like to talk to you about is the one that is also important, but it's the right to be reasonably protected from the accused. What do I mean by that? I have seen lately an uptick in increasing harassment through the social media by posting graphic pictures, statement, and other various electronic messaging against victims. Well, the CVRA makes it clear that you cannot condone this behavior. As I indicated, my role is simple. I ensure that the victims are afforded the simple 8 rights prescribed in the CVRA. One cannot simply look at a victim as a piecemeal approach. I understand it, but we must look at it in the entire body, and that fits that individual. I'm often reminded, and let me close by saying this, victims are not asked to be victims, but for one tragic event, they are at the mercy of others and at their mercy for the passion and commitment of others to assist them. And with that, I thank you, and I look forward to answering your questions.
Any questions? Okay.
Go ahead, please.
You know, the interesting thing here is that victims' rights are a relatively new body, both of law and certainly relatively new in the consciousness of everyone. And I think that one thing that is critical, and I don't think I'm saying anything different from any of you, even though you take different positions on the counsel issue, victims' counsel issue, is that the law exists and it should be enforced by the court, number one. And I think it is in the manual for judge advocates what the victims' rights, an essential outline of the Victims' Rights Act. And it should be enforced by the prosecutor, and not all of it perhaps, and that's where the dividing line comes in. The prosecutor should understand that the victim has a right to be present at certain critical moments in the trial. Forget the trial. I mean, before and at a plea, for instance, with respect to bail issues, all of that sort of thing. It seems to me that a well-trained, experienced prosecutor who also has a victim's advocate teamed up with them can be an extremely perfect combination to provide all the support that victims need. And I understand as an old prosecutor, both a former prosecutor and old, that I had a very special relationship with all of my victim witnesses, and I never thought they needed anybody else. I considered them to be their lawyer as well as the state's lawyer. So I know where Ms. Stamos and Ms. Fisher are coming from. I guess I wonder, though, whether they're, and here's another problem, this notion of privacy rights. and we've talked, a couple of people have mentioned sheltering the victim from subpoenas, for instance. Well, the bottom line is some of that information may be relevant and exculpatory, and so that creates an issue in terms of the justice system. You know, when a subpoena comes in, it's a case-by-case decision. Sometimes a judge will simply not grant it because it doesn't seem to have any basis at all by the defense. Other times, the judge will look at it in camera before it's given over. But it seems to me I would prefer that system in terms of the defendant's, the accused rights to be the system, rather than to have, at least in that one area, a victim's counsel who starts to get in the middle of a decision about what to turn over and what not to turn over in a criminal case. I think that ultimately has to be the decision of the prosecutor. This is just my own experience here. So I do worry about a tension that gets created. But I think what I'm learning, because as I'll tell you, my knee-jerk reaction was you can't afford to have a civilian counsel in the civilian world. It's not happened. It's very difficult. There's no resources. What I think I've seen in the military pilot project is that in that particular justice system for victims of sexual assault, this is an additional person who is a support to that person and empowers that person, and is a sign that the military considers this victim important and is going to be, they're going to be taken care of. Those are valuable things. I know you were all here before, and my only concern is, can it be sustained? It's extremely resource intensive, which and to say expensive is the same thing. So I don't know, I just throw all of that out as my reactions to what I've heard. And Admiral Houck, you want to save me the question, which wasn't a question?
Well, I mean, I think this is one of the great panels that we've had, because it's really awesome to have your range of experience and expertise here, and also terrific to see you taking different points of view, which is really helpful to us, I think. One of the things that, I guess to tack on to what Judge Jones said, one of the things that I wonder about is the role of, if you have a classic prosecutor who works with the victim beyond the scope of the criminal case or the prosecution, because I don't know if any of you were here this morning, we talked about it, the array and the morass of other issues that are out there for survivors is extensive. And one of the things that's attractive to me about the way that the military is going right now is the notion that this person is there for them during the criminal proceedings, but not necessarily exclusively for that. They can help the person navigate the rest of this process that's out there. So and I guess I would ask Ms. Fisher or Ms. Stamos, in a civilian system, what happens when the case is done? Do your prosecutors work with people throughout the whole range of other issues that are out there for victims? I would think not, but...
We have a justice center in our office that has a lot of volunteer lawyers and lawyers that work for different organizations around the city that has offices in this justice center that's attached to my office. So oftentimes I will send victims there to, get the divorce finalized, or to legal services to sue the landlord if they've been raped because the door was broken, and so on. So we do try and help them with counsel for that kind of thing, for sure. And we do what we can. I just feel like having that person in there in the middle of it, possessing information that I don't have, that I could get surprised with at trial, could be devastating. And maybe justice will be done in some of those cases, and maybe it won't, depending on what the privilege is. But we do try and assist them with those kinds of issues. And just to respond to you, Judge, and your concerns, I will tell you that I recently tried a case where a young woman came from Mexico to live with her aunt and was raped by the uncle because they wanted her to have their baby.